The question is that the motion be agreed to. The Honourable David Cunliffe.
Thank you, Mr Speaker. You know, from one geek to another, it is really quite endearing to see the Minister taking such pleasure in his role and being both joyous and excited about the land transfer bill. Word of advice to the Attorney-General, you really need to get out more. Labor supports this bill, Mr Speaker, and I know that if this was a committee stage debate, you would be holding us to every comma in every clause. But it is an opportunity at the second reading, sir, to just note the why and the how before we get into the detail of the what. Labor supports this bill because it is a long overdue update on the land transfer mechanism and a restatement of some of the core principles that govern indefeasibility of title and our torrent system of land registration. Sir, it's the second bill that I've had the pleasure of supporting in the House this evening, but it is also the second bill that has had its genesis in a review that has been conducted by either officials or an independent agency, in this case in 2010, in the previous case in 2009. And so I would observe that the wheels on the Treasury benches are not turning quickly. Either that or the government is resting so firmly on its laurels, sir, that it has got down to that pile of long-awaited legislative reform which has hitherto been buried in the bowels of the Law Commission or some other worthy institution. Mr Speaker, this bill did have its genesis in a Law Commission review in 2010. It was a good piece of work. It's been, I think it's fair to say, heavily engaged with by the legal and conveyancing communities, particularly with the conveyancing section of the New Zealand Law Society. And I think it's a fair point to say that the committee which reviewed the bill, the Government Administration Committee chaired by the Honourable Ruth Dyson, took a great deal of notice of the submissions of the Law Society. And no doubt Crown Law itself was heavily engaged. So this might be, the Minister said, a geek's paradise, certainly a lawyer's paradise. And while it may not be perhaps the most contentious piece of law in the country, it certainly is very important because all of us, well, perhaps not myself because I don't currently own a property, but people who do own properties want to have certainty of title. And that has been the fundamental principle that's guided the law, that people can rely entirely upon their land title because that supports the mortgage. That's terribly important to the banking industry, and it's one of the fundamentals that we get up in the morning and we clean our teeth and have our breakfast and we go to work and we just take it for granted, but it is important. So the law needed updating, Mr Speaker, because it had three different acts governing it, the earliest of which was written in 1952, not only before the internet but before the computer. And certainly now that we have our Land Online system at Land Information New Zealand and we have electronic passage of title, the law was several generations old. So Labor is supporting this bill because in general terms we realise that this is a necessary update. However, here is the real political context of the bill, sir. Not only that it's a worthy piece of detail heft which has been hauled from the basement from 2010, it's also a little bit of a dance of the veils because everybody knows that the real issues around land transfer are the massive swathes of land that are being bought up by overseas interests, and that's not necessarily bad before members opposite have an apoplexy. Let me finish the sentence. Not necessarily bad to have foreign investment. We need foreign investment, but we want an onto it Land Information New Zealand and an onto it Overseas Investment Office. And I challenge any member opposite to rise to their feet and give a 10-minute defence of the Overseas Investment Office, because every member of the government benches knows what we know, that it's currently a wasteland that is barely functioning, that is a wet bus ticket, that can't even do an internet search, and in order to catch somebody out, you've basically got to be wanted by Interpol. That's how bad, Mr. Speaker, that part of the land transfer system is. But notwithstanding that piece of political context, the substance of this bill, rather aged like a good wine, and certainly worthy of the Attorney General's detailed perspicacity, sir, the bill heads in the right direction. It updates the law and it allows for a reconsideration of issues like compensation, indefeasibility of title, identity verification, covenants in gross, withholding information on people's safety, liability of estate administrators for certain costs, and issues around the adverse possession process. But I'm going to concentrate in the balance of my remarks, Mr. Speaker, on the 2 or 3 major issues that the Government Administration Select Committee, so ably chaired by the Honourable Ruth Dyson, considered in its extensive deliberations. The first was the issue of mortgage fraud. Now, the draft as introduced had the perhaps laudable aim of requiring mortgagees, in this case the banks, to have taken reasonable efforts to satisfy themselves that the identity of the mortgagor, the borrower, was in fact real. And that is particularly important in respect of overseas transactions. It's also important for the integrity of the law domestically. However, unsurprisingly, the Select Committee room was full of the well-coiffed representatives of the banking industry who were at pains to point out that the transaction costs and the compliance costs of those obligations might in some cases be extensive. And the committee took some note of those submissions, and it looked at the differences between Australia, which has introduced similar requirements, Mr. Speaker, and New Zealand, which has an electronic land online system, and it decided on balance that for now, universally around the committee table, that the costs of the measures were not yet demonstrated to be worthwhile relative to the benefits. And so the committee's adopted a wait-and-see approach, agreeing with submissioners that those clauses should be struck, but urging the government to take an active review to ensure that we do not get increasing levels of mortgage fraud. The cynics amongst us, the member may choose to count himself amongst that throng, the cynics would say that a government that can't even maintain a register of foreign buyers or look through shell companies might not be the kind of government that you want to keep tabs on the family silver. And the member might not be wrong. But in an unbelievable show of generosity, the Labor opposition is willing to give them a chance to prove themselves once again in the eyes of the public to be the kind of government that could do something like this in less than 10 years that it's taken them to get this bill to the House. So that was our view on mortgage fraud. Manifest injustice, sir, that is when somebody swindles somebody else, and there's a tension in the law, if I can put it really simply, between the need to protect indefeasibility of title. When you've got it, you know you've got it, versus having some protections for people who are just out and out swindled. And the committee wrestled with some very learned submissions from the Law Society and from our departmental advisors, none of whom are still in the chamber to witness this exposition of the argument. And on balance, the committee felt that there should be a high bar around not just fraud, but a very high grade of fraud for it to be sufficient to overturn the historic principle of indefeasibility of title. And so, by consensus, the committee worked its way to some amendments, which I'm sure, with the Speaker's help, we will consider on a sentence-by-sentence, comma-by-comma basis in the committee stage of the debate. Compensation issues arise, sir, in that context. Time will not permit me to go into them, but when we get into the committee stage, we will go through the interface between manifest injustice, indefeasibility of title, and the compensation regime. Mr. Speaker, to sum up, this is a good little bill. It helpfully updates the law, some of which is even older than members opposite. But, sir, it has taken rather a slow track. A 2010 Law Commission review, it's a bit like the last bill on agricultural chemicals with its 2009 review. You know, either the government hasn't got anything better to do, or it should learn to do these reviews a bit quicker. Thank you, sir.